trouble in your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make your whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to another day. I am your grateful host, your gracious host, Daniel. And to all the new subscribers to this channel, welcome. Thank you for your support. I really do appreciate it. And if you like this kind of content and you're not a subscriber to this channel, do me a favor and hit that subscribe button and all notifications. Let's build this channel up. Let's get it past 500 before the end of this year. And May 10th is the 1-year anniversary of the creation of this new channel. So mark that on your calendars. I don't think I'm going to do anything special, but that's when I recreated this channel. Today is Judge Raquel West, another great judge. So yes, I'm going to be here watching. I'm going to be watching for ads. I'm here. I'm going to mute my mic so you can't hear what's going on in the background. And let's get started with this. Share. Make it bigger.
Good morning. Are you Crystal Bogan? And Ms. Bogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes, I have.
And any additions or corrections or?
There's a lot of history we understand on, but discussed it with counsel also with restitution.
Speak up, I'm
I
sorry.
just want to make sure the court knows the restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 1, 2, 3, and a quarter pages of criminal history. Oh. Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed, at least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but she's on probation right now in Sutton County, correct?
Yes.
Right. So do they know about this case? And what has happened over there, if anything?
I'm continuing on my department.
Are you over the age of 50?
Because I'm actually supposed to start nursing.
I can't understand you.
I'm supposed to start nursing school.
When?
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes,
school
ma'am.
with this type of criminal history?
Yes, ma'am. Even though I haven't been convicted of it. I'm a CNA now.
Where do you live now?
In Houston.
Another issue that I see on here also is the restitution, because it shows 9,400, but then that was from inside the bank, and then it shows 500 from an ATM and 100 from a cash app, totaling 10,000, not 9,400. Is that correct?
And that would have been added on, I guess, a bank fee.
Well, it says 500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the card.
Okay. So possibly the other person that was involved did that?
The only thing we knew about
That was,
the 100 that gets in the bank.
I wasn't aware, Your Honor, when we did it and got when I got the PSIs, when I was notified, I was in the cash wrap. But if it was a withdrawal, then that would be her responsibility, joint and separately.
Right. It says, so
Just a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of 10,000, 94 from inside the bank, 500 from an ATM, and 100 from a cash app transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of
I don't have the other status of another person, Your Honor. This is one that was in charge. But not there's a person on there. But
Okay.
she was responsible.
Yeah. So, I mean, if there was another person and you didn't give that information, then that's, okay. Apparently the cops didn't either, so.
She went in the bank, she was in the house. Well, I'm not the other. The fact, not to my knowledge.
And hold on. So the probations in Sutton County, have they been transferred to Harris County? So you're going in person in Harris County? Okay. And so it's the state's position to go forward with the agreement?
I understand the court's concern, the state has the same. Like I said, our initial deal was to get some of the money back on our victim. However, we understand.
All right, so here's what I'm going to do, Ms. Bogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly.
Excuse me.
I'm not. I can't. There's no way. It has to be straight probation. And I realize that that's going to potentially it have some issues, but I can't with 14 prior felony offenses, same type of thing. So
I don't.
you
No,
you do.
no, I don't. No, I don't.
Okay. How many do you think you have?
I have 3 here and one back home.
Okay, you have lots of them that were at the same time for different offenses.
You know, never convicted, never told.
Yeah, you did probations for them. Forgery of a financial instrument. March, don't talk over me. March 3rd, 2008, Harris County, 180 days in jail. So that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation. So that's 2 in Ohio. March of 2014, theft, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all of that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm going to run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit. And that's the 10-year probation that you're on in 5 different cases. That's not correct.
No.
So how many cases are you on probation for in Sutton County?
It all ran together. So.
I understand it all.
It's one.
It doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see if back in 3 weeks, y'all can talk about it then. You're at, ma'am,
What?
this is not going to help.
It's not matter what I thought.
Well, looks like you did that, not me. I'll see you in 3 weeks. Come on, hold on, get her, don't let her go. Come back. Everybody heard it.
You're bullshit.
Come back.
Sure, lawyer.
So my lawyer, she was bullshit. I didn't say this.
You don't talk like that to anybody in this case because he didn't do this either, you did. He did he did a great job. I'm going to find at this time that your bond is not sufficient because of your attitude and because of your
I gotta go to work. So I'm gonna lose my dog and everything too.
Well, maybe you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're going to make it worse. You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. All right, I'm going to set your bond at $25,000. Go back with the bailiff. So, again, you are Jarrett Matthews, and Mr. Matthews, get back to my, get back where I need to be here, hold on. It's clause number 23, DCCR 1211, and Mr. Matthews is charged.
This right here sets the stage for everything. Unlawful possession of a firearm by a felon. A serious charge that tells the court one thing: the defendant has a prior conviction, and now they're accused of breaking one of the strictest post-felony restrictions in the U.S. It's not about just owning a weapon. It's about trust, rehabilitation, and risk to public safety. So the stakes? Very high.
With unlawful possession of a firearm by a felon from September 13th of 2022, Mr. Kimler has filed a motion asking that I reduce his bond, and bond is currently set at $30,000. It looks like, is that correct, Mr. Kimler?
I think it was more than that. Yeah, it was it's 100 is what I thought.
So it was initially set at 30. So let me see here. Okay. So I wonder why.
We'll take 30, Your Honor.
I'm sure you will. I'm just looking at, okay, so apparently back in September of 2022, there was a bond set, and then I guess Mr. Matthews made that bond.
Then he went to custody of Louisiana and stayed in custody.
And when he got back, it was reevaluated in a bond set at $100,000.
Right.
So I have and will take judicial notice of the court's file, including the probable cause affidavit, the magistration document.
Now, this is where the defense starts playing their card, asking to reduce bond. Think of bond like a financial promise. Pay the amount, and you get temporary freedom until trial. But when you've got a record and multiple jurisdictions involved, like here with Louisiana, the judge has to decide, is this person likely to run again? What would you do if you were in the judge's seat right now?
That was used at the jail, and also the public safety report. Mr. Kimler, you may proceed.
Your Honor, I suppose the initial bond was $30,000, and then, of course, he accrued the cases in Louisiana, was in custody on the next court date, so was unable to make that. I don't think there's been any type of intervening circumstances from the time that he got the $30,000 bond and now that would warrant an increase in the bond other than just being out of state incarcerated.
Well, that we didn't have the public safety report system back in 2022, so I'm sure the new magistration process, that magistrate looked at the several pages that are included in that.
I'll just let Mr. Matthews address the court, then Your Honor, he can explain his current.
Raise your right hand the best you can, please, sir. Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, go ahead.
Explain to the court what your current situation is as far as your living arrangements, where you would be residing, and what your plans are.
I still stay in Lake Charles with my mom. From when I bonded out here the first time, I never missed court. I never failed the drug test and any of it.
But you were in custody in Louisiana for something between then and now?
I caught a charge prior to the charge I caught out here.
Okay.
This is my most previous charge.
Most recent.
You're right.
Most recent charge.
And what was that charge?
It was a convicted felon firearm charge.
Jefferson Davis Parish, right?
Yes, ma'am.
And what was your sentence?
4 years. I was in the military 7 years.
4 years. And listen closely. He mentions military service and PTSD. That changes the emotional tone instantly. The courtroom isn't just dealing with a criminal history now. It's dealing with a veteran, possibly struggling with trauma and reintegration. Judges often balance empathy with accountability in moments like this. Should his service earn him a second chance, or has that window already closed?
I have a little PTSD. I was going to dental appointments before I got incarcerated.
All right. Anything else?
It's a 4-year offer, Your Honor. He's wanting to try to get probation, so I would like to try to get him out, maybe to get established a little bit to show that if we come back on a contested sentencing, that he could do the probation. Is that what you believe?
Yes, sir.
Did we have a hold on him when he was in?
It's my understanding, Judge, and the reason for the offer being, obviously you see the offense date is quite old.
Right.
He should have had a hold at some point in time. I obviously appreciate his military service and will be willing to work with him on that. My problem being is that he's not a resident of this county.
Right.
Well,
So,
for Veterans Court, right? But I
Right.
think we could transfer the probation.
well, I guess if he wants a probation, that's one thing, and that's up to them to offer that. If he has been incarcerated for most of this time, then we can make that, even if we didn't have a hold, I can make a finding that we should have, and if you get that documentation on how long he was in custody there between the time of the indictment, nothing before the indictment,
Right.
but the time of this indictment and now.
We put a hold on pre-action 24.
Okay, so obviously would need to go back if he was in custody, but I would need documentation of that. And so I don't know if that's something you guys want to take into consideration.
And that's what my notes have reflected, the credit for the time that I was anticipating we would have had a hold, because he's been in custody at least 18 months now.
Right, which, I mean, it's,
He's asking
he would have enough.
18 months behind bars, and the defense is arguing that's already time served. But here's the twist. Without official documentation proving a lawful hold from the Texas court, that time might not count. These procedural details, dates, jurisdictions, paperwork, they can literally mean the difference between walking free and serving years more.
Time under his belt. And I understand what he's asking, but I don't know if y'all want to visit about that
I've explained.
opportunity.
He wants an opportunity to do probation, so.
Well, that's between y'all then. And so,
Well, it
then,
could be a-
all right, back to the bond.
Could be a
So,
gap, Your Honor.
look at one more thing real quick. I mean, so here's the thing. He's obviously a convicted felon, picked up an unlawful possession of a felon over in Jeff Parish, picked up another one after that over here. So at this time, based on all of the information that I've received, again, from that public safety report, as well as the criminal history, the facts of the case, I'm going to deny the motion to reduce the bond. You guys can visit about any options, and then we'll get it set for an announcement.
Yes, sir. I'll try to maybe figure something out.
All right, thanks.
We'll talk about that.
All right, so you're Stephen Boudwin? Yes, ma'am. And let me get this pulled up. Is it?
And so if I can,
Hold on just a second. Let me just get what I need to, and then I'll let y'all. Oh, I know. Would you call the name Tiffany Guillory, please?
This is the one I talked to Your Honor about
Yes.
on Friday. She bonded to know.
she actually, I wasn't sure about this. When he called me yesterday and about a bond hearing. I was thinking it was but I had requested a bond, didn't realize what it was. I said, well, you probably don't need to be there because he's already pled out on the case and we were waiting on a PSI. And we were looking at, we were going to see what happened with parole. I think he's been released from parole. The parole hold's been lifted.
No response.
And then I get a call from her, and she started explaining. I said, well, he needs to be there for the bond hearing. I don't know all the ins and outs about the issue about the increase of the bond, but she informed me as well that she had signed the bond to bond him out, and she sent a letter to the court, I believe, which was
I
forwarded.
have it.
to me. And I told him that he needed to go and contact the probation department to do a PSI. I mean, I just told him yesterday, I don't know if he's contacted him yet or not.
Yes, they scheduled me to come in today. So I'm coming off the court.
Ms. Malfino?
Thank you, Judge, and thank you again for your time while you were on vacation this weekend, and I was dealing with this matter with Ms. Guillory, who came to my office in tears, also tried to come to the court. I confirmed with your coordinator about that, in tears, about how fearful she was of this gentleman. So I immediately turned around and filed a motion to increase his bond, which time Your Honor graciously added some conditions of a GPS, et cetera, et cetera. I spoke with parole on Friday before I talked to you, Judge, and they were going to lift the hold. So that's when you put those conditions in place. I since have learned that obviously Ms. Guillory has now had a change of heart. She actually posted the bond herself. I was going to ask the court to reject the probation offer that I had given him, but in light of her actions, obviously I filed it, as the court knows, and you and I have both experienced, when someone expresses that level of concern, it's not something that we take very lightly, and yet her actions have proven that that was not serious to her, even though we all took it seriously. And so I would leave whatever decision you make, Judge, to your discretion. I'm not really concerned about the bond at this point.
So here's the thing, Mr. Boudwin. I'm not going to increase the bond based on what we...
Whoa, what a shift. We've gone from legal technicalities to a human drama about fear, control, and safety. The alleged victim, Tiffany Guillory, once terrified of the defendant, now bails him out herself. That contradiction? It's something courts see too often, emotional whiplash in domestic cases. But the judge lays it down hard. No contact means no contact. This is where law meets human unpredictability, and the court's patience wears thin.
Learned. However, a condition of your bond is still, and what has been the whole time, that you have absolutely no contact and no communication at all with Tiffany Guillory. She cannot give you permission to violate that order. Do you understand? So I understand she went and bonded you out. She's written me a letter. At this point, I don't care about any of that. Period. Now, once you're on probation, maybe some of that will change, but as of right now, no communication, no contact. That's in person, that's through your phone, that's through sending messages. Again, she cannot say, it's okay, I won't tell. If something happens and she changes her mind again, which is likely, it sounds like, and contacts Ms. Malfino and says, okay, I thought it was okay, but now it's not, he's coming around, you're going back to jail and you probably won't have a bond. That's how serious I am about this. Okay, so we'll reset it. You need to take care of your pre-sentence report. You need to talk to probation, go there today, get that set up, and then we'll see where we are when we come back for sentencing. And you have that GPS device on? Okay, make sure you keep it charged, make sure you pay for it, do everything you're supposed to, so that I know at all times where you are.
I assume the sentence is still the same as on the 18th?
Yes.
Okay. Okay.
All right. Okay, you're free to go.
Thank you, Judge. I just felt it important to document.
I totally agree. Thank you, Ms. Malfino. In the back that I think we need to put on the record with regard to the case and where we are. We have, first of all, Sir, your Dalvius Williams. And Mr. Williams is here with Mr. Rojas. Mr. Smith is here on behalf of the state. There is a second amended motion to revoke unadjudicated probation. So because the new allegation, I'm not going to accept the plea agreement of the cap of 4 years because there's a new. So I will allow, if Mr. Williams wants to of true to 1, 2, and 3, I can go through those again and get pleas today on those, and then we can go forward with what we have today. And then if I feel like there needs to, is my understanding, Mr. Smith, for today, you have witnesses with regard to proving up count 4 only. Is that correct? That's correct. So what we can do today, depending on what those pleas are, either way, we'll go forward with what we have because there's witnesses here. And then if I feel like I need to postpone the hearing to another date for the state to prove up more, then we can do that then. So, Mr. Williams, the best you can, I need you to raise your right hand, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can put your hand down. And so, Mr. Rojas, what is y'all's position?
Judge, I think after discussions with Mr. Williams, I think he would like to withdraw his plea of true to count number 3.
Okay. So just to go back, count 1, Mr. Williams alleges that you violated your probation by failing to report to the probation department October 25th and December 15th of 2022. You had previously pled true that that was true. And do you want to continue to plead true to that count? Okay. And then count 2 alleges that you're behind in your court-assessed fees as of January 4th of 2023 in the amount of $3,638. You previously pled true to that count, and do you want to continue with your plea of true to count 2? Count 3, which was in the added in the first amended motion, alleges that you committed the offense of evading arrest or detention July 14th of 2024. You had previously pled true to that count, and do you want to change your plea to not true? Okay, so we'll enter a plea of not true to that count. And Mr. Smith, I know you weren't prepared, I guess, for that, but have y'all had any contact with the officer? I would think that would be a one witness.
It's actually several witnesses, Judge.
Okay.
They're going to serve a warrant at his house. There were 2 officers in the back that see him come out of the back of the house.
Okay.
Knocking on the front door, so we need both of them.
Okay. Okay. All right. So we'll see where we get today then. Mr. Williams is on probation for possession of a controlled substance, and that, which was a 3rd-degree felony, correct? No. That's been... Oh, it was as well. I've got the indictment pulled up from the injury to a child. That's a 3rd-degree felony. But that possession of a controlled substance is a 3rd degree as well. So the range of punishment is between 2 years and 10 years. And Mr. Williams, I also want to make sure you understand that if we go forward with this motion and I do end up revoking your probation, then later if the state does prove, so we have the injury to a child, that new case, if you're found guilty in that new case, then the punishment could be stacked. Do you understand? Do you understand that? Okay. Mr. Rojas, you've gone over all of that with him, correct? And it's also my understanding that y'all had, even in the back, Mr. Williams' mom in the back to go through everything, what his options were, and all of that this morning. Is that correct as well?
Correct,
Okay. What if any offers? I want to make sure Mr. Williams, on the record, rejects anything that's been offered.
We had offered 4 years in this case, Judge, and he is rejecting that offer.
Did that include an offer in the injury to a child?
Actually, I offered 4 years in both cases to run concurrently.
Okay.
If he went today.
Okay.
He said no. And I told him that if he didn't do that, if we go to trial on this, then the 4 is off the table on this case.
Okay.
I apologize. Mr. Smith talked about the 4-year offer for today to the possession of a controlled substance. And if he were to be tried in the future, if he were to be convicted for the injury to a child, that case would be stacked.
He would request it, and it's up to me. So anytime the state asks for a case to be stacked, it's up to the court to do that. So it's not up to a jury. If you go to a jury trial on that injury to a child, what would happen? Let's say you go forward today, we have this hearing. If I revoke your probation and give you any time in prison, then the next step would be to set that injury to a child for a trial. And then if you're found guilty in that case by a jury, then what the state is saying is that they would ask me then to stack that, whatever sentence you might get, if you get a sentence, on top of what happens today in the motion to revoke probation. Do you understand? Okay. And so your options are today, if you wanted to go forward with a plea in both of your cases, plea of true in that motion to revoke for a 4-year sentence, plea of guilty in the new injury to a child case for a 4-year sentence, with the agreement that those sentences would run at the same time. You don't have to do that. We've got witnesses here. We'll go forward with the hearing. Just want to make sure you understand what your options are today that you won't have after today, and what your consequences could be if you go to trial and if we go forward. And nobody's trying to talk you into anything. I just want to make sure you understand it all. Does that make sense? Okay, so you understand everything that's been offered and what what you could do today and kind of where we're about to go, right? And so what do you want to do?
Any truth to first, but not to the injury to the child.
Okay, then we'll go forward with this hearing. So I want to make sure also for the record what all I've reviewed. The original PSI, obviously from being placed on probation, is included with the updated pre-sentence report. Everyone should have that as well. And so when I went back through that, I just want to make sure that there aren't any corrections or issues with regard to that criminal history specifically that I'm looking at. It starts on page 1 and then carries on to page 2 on that pre-sentence, or actually it was a post-sentence investigation, I think. Y'all have that? Everybody's on the same page as me?
Yes.
So it looks like there was adult misdemeanor history of 2 thefts back in 2013. Both of those were 30 days in jail. There was a theft of services in 2014 where Mr. Williams received a probation. That probation was revoked in 2016. That's in Rusk County. Possession of marijuana in 2014, Nacogdoches, 3 months in jail. A resisting arrest or search, March of 2015, where there was a probation given that was revoked in 2018. There was then a 2015 failure to appear bail jumping case in Nacogdoches. 2016, burglary of a vehicle, 30 days jail, and then 2019, a resisting arrest again and an evading arrest also in 2019, both with 180 days in jail. Then the felony criminal history I show is a criminally negligent homicide from 2017, where a probation was given in 2018. That probation was revoked in 2020. Looks like that probation was revoked based on, and looking back on all of this, I'm not real sure other than what we were all thinking, but it looks like on January 10th of 2020, the probation was revoked on the criminally negligent homicide. There was a new offense of injury to a child that he appears to have pled guilty on and received a 12-month state jail sentence. From January of 2019, an attempt to take an officer's weapon, also same disposition date of January 10th of 2020 for the 12 months in the state jail. And then there was this possession case that we're here from that same date. So it looks like he took some time on a couple of things and then got probation on the possession. Does that, everybody on the same page as that?
Yes, Your Honor.
I did look back. I think because I have this information, I don't think it's necessarily improper for me to look at some of the information based on those cases. I do have a question specifically with regard to the injury to a child from 2020 that he pled guilty on. What is the relationship with, that was the victim in that offense?
Was the stepson, Your Honor?
So Ms. Broussard has other children?
Yes.
That are not from Mr. Williams?
At least one, Your Honor, yes.
So when we went back through, Mr. Williams entered pleas of true to counts 1 and 2. So I am going to find, based on those pleas, counts 1 and 2 true. count 3, entered a plea of not true, as well as on count 4. I am going to find, based on the evidence presented today with regard to count 4, that there is sufficient evidence to find count 4 true, and at this time I am going to find count 4 true. I understand everyone's position. I think with regard to there'd be different evidence, I would think, and probably more potentially at a trial. I'm not required to look at all that, and obviously the level of the burden is different. So count 4 is true. Mr. Rojas, you may proceed with argument.
Judge, when we did the initial plea, we got the updated PSI report, and they were recommending that if probation were to be granted of ISF. Obviously, that can't happen with a new charge pending. He does have this new injury to a child that after speaking with the family, I don't think he's going to be able to bond out even if you were to keep him on probation. If the court is inclined to keep him on probation without ISF, we ask you to do that. If that's not going to be possible, Judge, we ask the court to consider something in the range for the possession case, 2 to 4 years.
All right. Thank you, Mr. Rojas.
Judge,
Mr.
I
Smith?
believe his criminal history shows very convincingly that he is unable to successfully complete probation. Speaking of probation officer, I don't believe it's their desire to keep him on probation with this type of charge pending, especially in light of the fact that he's already been convicted of injury to a child within the last few years. That tends to me to show more than just a pattern, it's a habit. The fact that he doesn't respect authority is shown by the jail incident reports. I feel like he needs to be revoked in this particular case, and we're asking for no less than 5 years, somewhere between 5 and 10 years as punishment in this particular possession.
Thank you. And also, just for the record, everybody has those jail incident reports. Those were provided. I've reviewed those as well. Mr. Barksdale's here. Mr. Barksdale, do you, the probation officer, do you have anything to add at this point with regard to your position?
No, ma'am, I concur with the district attorney.
Okay. Thank you, sir. Mr. Rojas, I would give you an opportunity if you want to. We can ask Mr. Barksdale to come if you have any questions of him.
No, Judge.
Okay. And Mr. Williams, you're 30 years old? You just turned 31. So I appreciate that you have support here and people here to support you, but your behavior to me tells me that you shouldn't be around any children, much less your own. Whatever is happening with you when you're getting angry at these children with what you're doing, because it's the same. This appears to be the exact same type of incident that you pled guilty for a few years ago when I put you on the probation for the possession. And this, it's ridiculous. You and Ashley both don't need to be around any children. Don't need to be having more children. You can't take care of your own children, and you're disciplining them by doing this. And I don't think there's any reason for anybody to believe that no one said these are scratches. No one's adjacent to these other marks on the back of this 2-year-old. Going to find, again, that you entered your plea of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find count 4 true. Find sufficient evidence at this time to find you guilty of possession of a controlled substance. I'm going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. I'm making a notation on this because originally it was a plea agreement that when it was signed, I'm making a modification. I need Yeah, let me change it. This was not a plea agreement, so you do have some rights to appeal. I'm also going to hand you a written admonishment regarding, hold on a second, regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. Thank you all. I'm sorry. I know this is difficult for everyone, but I have no doubt in my mind that Mr. Williams, not just on this occasion, but probably on many, has obviously improperly disciplined, if that's what you want to call it, all of these children. So, court is adjourned. All right.
Today's courtroom drama starts with a deal on the table, a plea agreement that could have capped this defendant's sentence at just 4 years. But when a new allegation surfaces, the judge throws that deal straight out the window. What follows is a tense back and forth between defense and prosecution, as a man with a long criminal record risks it all in front of a no-nonsense Texas judge. Watch closely, because this case goes from negotiation to devastation in minutes. And there it is, 8 years behind bars. What we just witnessed isn't only a legal process. It's the unraveling of a man's second chance. From the moment the judge rejected the plea agreement, the tone of this hearing shifted. Initially, the defense hoped for leniency, that probation might still be an option. But once the state introduced new allegations, the court's hands were no longer tied to the 4-year cap. Under Texas law, when a probation revocation involves fresh criminal conduct, the judge gains full discretion to impose the original sentencing range, here anywhere between 2 and 10 years. Mr. Williams' decision to withdraw his plea of true on count 3 might have seemed like a smart move in the moment, a chance to fight back, but it came at a cost. By contesting that count, he opened the door for the state to call witnesses and prison evidence, effectively gambling with his own freedom. Once the prosecution brought up the prior injury to a child conviction, his history became impossible to ignore. And that's where this case became more than just paperwork and procedure. The judge wasn't speaking from anger. She was speaking from exhaustion. She'd seen this defendant before. The pattern was clear: theft, resisting arrest, probation violations, and even a homicide case. Each prior second chance ended the same way. So when the judge said, "You shouldn't be around any children, much less your own," it wasn't hyperbole. It was a reflection of how the legal system eventually stops offering grace when the behavior never changes. This case highlights a reality most people don't see in viral courtroom clips. Probation isn't freedom, it's a test. And every failed check-in, every unpaid fee, every new charge stacks against you until the judge has no choice but to revoke it. The justice system runs on patterns, and Williams' record told a story of someone who couldn't or wouldn't stay on the right side of the law. For the viewers who might be wondering, yes, 8 years may sound harsh, but within the Texas Penal Code, that's the lower half of the sentencing range for a third-degree felony. The judge could have easily gone higher, especially with the injury to a child case looming. In fact, if he's convicted in that new case, his sentence could be stacked on top of this one, meaning he serves both terms back to back. That's the part that chills most defendants. Once probation is revoked, there's no safety net left.
Good morning. Are you Melissa Taylor? What do you have on your...
Oh, this is my son, Brandon Taylor.
Uh-huh. Why'd you wear that this morning?
Because he's my entire world and I'm missing him.
Okay.
Right away, you can feel this mother's desperation. Wearing her son's photo to court, that a bold emotional move. But in a courtroom, emotion doesn't outweigh evidence. Watch how the judge stays calm and measured while Melissa's story begins to unravel.
Miss Taylor, this is your initial... No, you were here before. Did you get someone hired?
Ma'am?
Did you get someone hired?
No, I have contacted 4 different attorneys. I have to print out paperwork about all the information. They're extremely expensive. I'm not going to get the funds gathered for that.
Who'd you talk to?
I spoke to down.
Where? Where'd you?
Right in the phone.
Okay. Did you talk to some more since that last court date?
The last hearings.
Uh-huh.
You asked, you instructed me to get 3 quotes.
Mm-hmm.
That was what I did. I can get that turned into after.
Okay. If I test you this morning, you can have anything in your system? Have a seat in the jury box. Need to text. Ms. Taylor, you tested positive for amphetamines, methamphetamines,
And here's the breaking moment. The drug test results. Methamphetamine, ecstasy, and amphetamines, all positive. Under most U.S. bond conditions, that's an instant violation. Judges have no discretion here. It's custody on the spot.
ecstasy. And so at this time, I'm going to find that that is a violation, obviously, of your bond conditions. And I'm going to raise your bond in your case to $100,000. Well, let me look at it real quick. I'm going to, let's see. In one of your cases, you're charged with assault on a peace officer, the other credit or debit card abuse. In each of those cases, I'm raising your bond to $100,000 in each case. If you make the bonds in those cases, you are ordered to wear a drug patch at all times, get it tested at the appropriate times, and then we will move forward with your case.
Can I ask a question, please?
Mm-hmm.
Am I about to be arrested?
Yes, you're going into custody right now.
I have a child.
Listen to this moment carefully. She pleads, mentioning her child, but the judge shuts it down immediately. Do you think the judge went too far, or was this firm justice? Comment your take below. Empathy or accountability?
You shouldn't be using ecstasy and methamphetamine. If you have a child, you can go back with the bailiff. Go back with the bailiff right now. Go back with the bailiff. Go with the bailiff.
My child is missing, and he's with a terrible person.
Good morning, sir. Are you Christopher Paul Davis? And Mr. Davis, this is your initial. Good morning, sir. You're Denzel Lewis. And Mr. Lewis, you were previously in court, entered a plea of guilty to the third-degree felony offense of unlawful possession of a firearm by a felon. The agreement was for a cap of 6 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, sir.
Are there any additions or corrections?
Just argument from the defense.
In addition, I have received the jail incident reports, which have been turned over to counsel. Have you both had an opportunity to review those?
I have.
Also, I have received this morning and now reviewed, it looks like 4 letters of support that Ms. Holmes brought today. Mr. Smith, have you had an opportunity to review those as well? All right, then Ms. Holmes, you may proceed.
Thank you, Your Honor. In looking at the PSI report, Mr. Lewis does have obviously previous criminal history spanning from juvenile and to adulthood. The priors that he has, it appears with burglary of a habitation. It looks like 3 cases, but they ran concurrently, in which he was placed on probation and had a revocation, in which he was sentenced to 8 years in TDC. He has since been discharged from that, Your Honor, and after being released, there was this traffic stop, which resulted in a firearm being found in the vehicle in which Mr. Lewis was driving. Obviously, in reading his response to the PSI officer, I would allow him to elaborate more on that. Obviously, he did plead guilty to the offense, taking responsibility, and we are seeking probation in this case, Your Honor. We believe that at this point in Mr. Lewis's life, he understands, obviously, being incarcerated before, that it's not somewhere that he wants to go back and spend potentially 6 additional years of his life. He would like this opportunity on probation to have that opportunity to spend and get back on track with employment, to take care of his family and provide for his family. And reading those support letters, Your Honor, he does have support here from family and friends in the community that are willing to step up and help him to make sure that he is a productive citizen and he gets back on track and understands that there's just certain things with being a convicted felon that he cannot do. And I think at this point he understands that, Your Honor, and we are asking that the court give him the opportunity to be placed on probation and to finish his term while on probation.
Well, I guess before we go any further, I want to make sure I understand because Mr. Lewis, your version of this is that it wasn't your gun. It was in your girlfriend's purse, and you didn't even know her purse was in the car.
Now, the next case is fascinating. A firearm charge tied to a prior felony. The defendant pleads guilty, but claims the gun wasn't his. Here's the twist. Under Texas law, possession doesn't always mean ownership. If it's in your vehicle and you're aware of it, you're legally responsible.
Less the gun was in the purse in the car. So either you are guilty or you're not guilty of the offense. And so if you knew about it, then you're guilty. If you didn't, then a jury needs to decide.
I'm pleading guilty because I was driving the car, and by me driving and then finding the gun,
But the law, that's not what the law is. Okay? So you don't get to just take a deal or plead guilty because that's what you want to do. When you were here before, you stood in front of that clerk, you put your hand up, swore that you were going to tell the truth, and I said, are you pleading guilty freely and voluntarily, or are you pleading guilty because you did what they charged you with? Okay. All right, Mr. Smith?
Judge, I think he's been given probation before. It was not successful. He's been revoked. His actions in the jail clearly show he doesn't have any respect for authority or rules. I don't feel like he's a proper candidate for probation, so we're asking for a 6-year sentence in TDC.
So, Mr. Lewis, one thing I noticed in several of these letters that friends and family members said, I think 3 of them actually used the word respectful, that you're a respectful young man. What has been going on in our jail is the furthest thing from respectful that I've seen.
This is where the judge absolutely loses patience. She lists off multiple jail violations. And let's be honest, this might be one of the most uncomfortable court moments ever recorded. The list of offenses, bizarre, explicit, and relentless.
The number of times, and the fact that I have to say this out loud, the number of times that you choose to masturbate in front of the officers on purpose is ridiculous.
I'll speak on it,
Sure.
That case wasn't on me. Somebody else had a case, and the woman even talked to the lieutenant to get it removed off of my file, but it still shows up. It was not on me. It's somebody.
It's more than one time. So hold on. So on April 14th, let's just go through them. On April 14th, you were in trouble for not being in your bunk, that you had been given several orders to go to your bunk. You proceeded to walk around yelling, "Bitch, stop talking to me." So that's from April 14th, last week. Then on April 7th, it alleges that you had your hands in your pants, moving in and back and forth, that you were told to take your hands out of your pants, and that you had been told before, or this officer had been briefed on the fact that you were known for doing this. Your response, according to this, is that that person should have asked the officers how big your penis, anyway. Since they want to be talking about you, they should have told them about that too. Then, on March 25th, before that, a week, so another officer, and these aren't the same officers. It's not the same person saying the same thing about you. Somebody has some vendetta against you. So on March 25th, started to do rounds. Notice that you were watching the person doing rounds. Had his hand over his midsection as if he was rubbing on himself. March 18th, another different officer. Notice monitoring the bunk. There you are, laying on your back, stroking your penis in a back and forth motion, told not to do so. January 24th, 2025, you're in trouble for walking around This one, notice the way you're laying on your bunk in a way, making motions under the blanket, walked past, turned around to see if you were still doing it. Then you supposedly look at this officer and say, I'm not doing anything, while you lifted the blanket up for that officer to see it. January 4th, another time, being told to be quiet, do what you're supposed to do, didn't do it that day. December 29th, another issue of not following the rules. December 17th, another infraction for arguing and not following the rules. So if there was one time when they got the wrong person, that's one thing. That's over and over again. You disrespecting female officers who are in there just doing their job.
Sleep on my bed.
Sir, we're really going to do that?
You asked me and I'm telling you, I sleep on my bed.
Uh-huh.
I have sisters. I have a mama. I don't do that. Them people write whatever
They're making this up on you. That's terrible of them to do that.
Look at my cases report now. I don't have any cases on none of that. I don't have any time. I'm not on no restriction on none of that.
Okay.
Up in the county.
You were off parole, the way I do the math, less than a year. So you did your whole 8 years? What'd you do in prison to have to do your whole 8 years?
I was in city.
For doing what?
Just tattoo, contraband.
Not following the rules while you're in prison. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by felon. Sentence you to a term of 6 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal, and you're lucky that this was the agreement. Mr. Smith was generous. The fact is, you could have been enhanced to a second-degree felony because of your history, and you're lucky you weren't. I have also handed you a written admonishment regarding your ineligibility to possess.
6 years behind bars. And that's actually a lighter outcome than it could have been. The judge even reminds him how close he came to a higher felony enhancement. It's a sobering reminder. Courtroom mercy exists, but only for those who respect the system.
Possess a firearm or ammunition. Obviously, you know this, but I'm required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to Ms. Holmes. You can go with the bailiff.
Never ever sue the
How old are you?
I'm 36.
You're 36 years old, so you needed to come here today and have her tell you you need to behave in jail? This is ridiculous. And we don't have punks like you acting like this and treating us this way when we're at our job. All right, so you're Jasmine Hancock? And so Mr. Hancock is charged in 25 DCCR 0737 with evading arrest or detention with previous convictions. Cause number 25 DCCR 0738 with continuous violence against the family. And then there's a third case. Those both have offense dates of the first one is April 22nd of 2025. The second one is April 26th of 2025. And then in cause number 25 DCCR 1233, there's a new evading arrest or detention with previous convictions from August 5th of 2025 that has now been indicted. And Ms. Holmes has filed motions in the first two cases asking that I reduce Mr. Hancock's bonds, which are currently set at $100,000. It looks like there was a court date on July 22nd of 2025 that Mr. Hancock missed, and so that was when those bonds were increased.
On July 22nd?
Mm-hmm.
Okay.
And then, so he missed court on that date. So there was, before that, there was an AFRS that was filed by the bondsman to get off the bond. But when he didn't show up, the bond forfeiture overrides that. And so that was the bond forfeiture. And then also, since then, there was a request for an emergency protective order. I'm also reviewing jail incident reports that I have received. Have you had an opportunity to review those? Yeah. Why don't you take a look at those, and then before you try to make arguments on behalf of your client who's making things very difficult for you, y'all can go review those, and then we'll come back and discuss
Judge,
the
I think if you
bond.
just let me review his criminal history, the decision will be very easy.
I've already know what I'm gonna do, but I'd be glad for you to do that as well. Go
Yeah,
ahead.
he's habitual on this continuing violence against the family case. He has a total of, I believe, 10 prior felonies. And on these 2 evadings, the state jail and evadings with prior evading convictions, he has a total of 7 evadings. And the most recent one was picked up when he was arrested in August while he had warrants for these pending cases. His priors that are not evadings include firearms, drugs, and burglary.
Okay. Ms. Holmes?
He had only been off parole about 2 months before the new offense date in April.
Honestly, based on everything I'm seeing, I'm not sure the bonds are satisfactory. We'll see. Ms. Holmes, any,
So, Your Honor, I was provided some documentation. Apparently, Mr. Hancock did go to the hospital in July, which I believe at the time he did provide that documentation to the bondsman. I'm not sure if he was aware that an AFRS had been filed at that point. He is aware that he needs to behave in the jail.
really, you're aware of that? How old are you?
I'm 36.
You're 36 years old, so you needed to come here today and have her tell you you need to behave in jail?
No, man.
This is ridiculous. These people are just going to work and trying to do their job. That's all. You know, I mean, that's what the rest of us do. We go to work, we do our job, we go home, we live our lives, and we don't have punks like you acting like this and treating us this way when we're at our job. The way you have spoken to the officers, the female, they disrespect you first. Do you think you earned their respect? You're in jail. You follow the rules. Their job's just to do their job. If it's time, you don't get to make decisions in jail. You don't get to decide when you turn the lights on and off. You don't get to decide when you go to bed or when you eat. It's not your decision anymore. That's what happens when you continue to violate the law. You've lost your right to make those decisions. So it's their decision to try to keep everybody in order out in the jail the best they can. And the way you have spoken to them and threatened them is actually a violation of the law, and you could end up with more cases for threatening a correctional officer. So just keep going, keep stacking it up. I'm sure a jury later will love to hear all of that. They'll love to hear it. You're looking at 25 to life on one of your cases. Keep it up. Let's see what happens. Because a jury will see all of this. And if you think I'm going to take some great deal that they're going to negotiate, or you think Mr. Nichols is going to give you some great deal, it's not happening. So you're old enough to know better. I'm going to deny the motions for a bond reduction in cause numbers 25 DCCR 0737 and 0738 based on several factors: your criminal history, the fact that you did miss court, the fact that your bondsman had already filed an AFRS, your jail incident reports. I am also going to find in cause number 25 DCCR 1233 that your bond is insufficient, and in that case I'm going to raise your bond to $100,000. A condition of all of these bonds, if you make them, will be that you will be required to wear a GPS monitoring device and you will be on house arrest. So if you make these 3 bonds, you will be on house arrest. You're not allowed to leave your house unless you have my permission. And you will be also ordered, and it should already be in a bond condition, in cause number 25 DCCR 0738, to have absolutely no contact, no communication at all with the complaining witness. Do you have that name handy?
I do, Your Honor.
Janesha Butler.
Janesha Butler?
Jamesh.
Jamayshha.
So you cannot have any contact whatsoever with that person. Do you understand? That also includes when you're in jail. So there's no sending messages through that email system or anything like that to her, through anybody else. That'll be a violation of your bond, and your bonds will end up raised even more. You understand? All right, I'll reset it for a for an announcement. We'll deal with all of the cases at that time.
Thank you, Your Honor.
Thank you.
Are you researching?
Good morning. Are you Melissa Taylor?
Yes, ma'am.
What do you have on your...
Oh, this is my son, Brandon Taylor.
Uh-huh. Why'd you wear that this morning?
Because he's my entire world and he misses me dearly.
Okay. Ms. Taylor, this is your initial... No, you were here before. Did you get someone hired?
Ma'am?
Did you get someone hired?
No, I have contacted 4 different attorneys. I have the printout paperwork. I got all the information. They're extremely expensive. I've not been able to get the funds gathered for that.
Who'd you talk to?
I spoke to, I have it down
Where?
a month ago.
Where'd you?
Grab it in my phone.
Okay. Did you talk to some more since that last court date?
The last hearings.
Uh-huh.
You asked, you instructed me to get 3 quotes.
Mm-hmm.
That was what I did. I can get that turned into you after,
Okay. If I test you this morning, you can have anything in your system? Have a seat in the jury box. We're going to text.
belongings.
Ms. Taylor, you tested positive for amphetamines, methamphetamines, and ecstasy. And so at this time, I'm going to find that that is a violation, obviously, of your bond conditions, and I'm going to raise your bond in your case to $100,000. Well, let me look at it real quick. I'm going to, let's see. In one of your cases, you're charged with assault on a peace officer, the other credit or debit card abuse. In each of those cases, I'm raising your bond to $100,000 in each case. If you make the bonds in those cases, you are ordered to wear a drug patch at all time, get it tested at the appropriate times, and then we will move forward with your case.
Can I ask a question, please?
Mm-hmm.
Am I about to be arrested in?
Yes, you're going into custody right now.
Okay, I have a child.
You shouldn't be using ecstasy and methamphetamine. If you have a child, you can go back with the bailiff.
So I
Go back with the bailiff right now. Go back with the bailiff. Go with the bailiff.
My child is missing, and he's with a terrible person.
Good morning, sir. Are you Christopher Paul Davis? And Mr. Davis, this is your initial. Good morning, sir. You're Denzel Lewis. And Mr. Lewis, you were previously in court, entered a plea of guilty to the third-degree felony offense of unlawful possession of a firearm by a felon. The agreement was for a cap of 6 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Are there any additions or corrections?
Just argument from the defense.
Nothing, Judge.
In addition, I have received the jail incident reports, which have been turned over to counsel. Have you both had an opportunity to review those?
I have.
Also, I have received this morning and now reviewed, it looks like 4 letters of support that Ms. Holmes brought today. Mr. Smith, have you had an opportunity to review those as well? All right, then Ms. Holmes, you may proceed.
Thank you, Your Honor. In looking at the PSI report, Mr. Lewis does have obviously previous criminal history spanning from juvenile and to adulthood. The priors that he has, it appears with burglary of a habitation. It looks like 3 cases, but they ran concurrently, in which he was placed on probation and had a revocation in which he was sentenced to 8 years in TDC. He has since been discharged from that, Your Honor, and after being released, there was this traffic stop, which resulted in a firearm being found in the vehicle in which Mr. Lewis was driving. Obviously, in reading his response to the PSI officer, I would allow him to elaborate more on that. Obviously, he did plead guilty to the offense, taking responsibility, and we are seeking probation in this case, Your Honor. We believe that at this point in Mr. Lewis's life, he understands, obviously, being incarcerated before, that it's not somewhere that he wants to go back and spend potentially 6 additional years of his life. He would like this opportunity on probation to have that opportunity to spend and get back on track with employment, to take care of his family and provide for his family. And reading those support letters, Your Honor, he does have support.
I can't believe the sleep apnea pillow exists.
Here from family and friends in the community that are willing to step up and help him to make sure that he is a productive citizen and he gets back on track and understands that there's just certain things with being a convicted felon that he cannot do. And I think at this point he understands that, Your Honor, and we are asking that the court give him the opportunity to be placed on probation and to finish his term while on probation.
Well, I guess before we go any further, I want to make sure I understand, because Mr. Lewis, your version of this is that it wasn't your gun, it was in your girlfriend's purse, and you didn't even know her purse was in the car, much less the gun was in the purse in the car. So either you are guilty or you're not guilty of the offense. And so if you knew about it, then you're guilty. If you didn't, then a jury needs to decide.
I'm pleading guilty because I was driving the car, and by me driving and then finding the gun,
But the law, that's not what the law is. Okay? So you don't get to just take a deal or plead guilty because that's what you want to do. When you were here before, you stood in front of that clerk, you put your hand up, swore that you were going to tell the truth, and I said, are you pleading guilty freely and voluntarily? Or are you pleading guilty because you did what they charged you with?
I was, and I still am.
Okay. All right, Mr. Smith?
Judge, I think he's been given probation before. It was not successful. He's been revoked. The actions in the jail clearly show he doesn't have any respect for authority or rules. I don't feel like he's a proper candidate for probation, so we're asking for a 6-year sentence in TDC.
So, Mr. Lewis, one thing I noticed in several of these letters that friends and family members said, I think 3 of them actually used the word respectful, that you're a respectful young man. What has been going on in our jail is the furthest thing from respectful that I've seen. The number of times, and the fact that I have to say this out loud, the number of times that you choose to masturbate in front of the officers on purpose is ridiculous.
Can I speak on it, Your Honor?
Sure.
The case wasn't on me. Somebody else had a case, and the woman even talked to the lieutenant to get it removed off of my file, but it still shows up. That was not on me. It's somebody.
It's more than one time. So hold on. So on April 14th, let's just go through them. On April 14th, you were in trouble for not being in your bunk, that you had been given several orders to go to your bunk. You proceeded to walk around yelling, "Bitch, stop talking to me." So that's from April 14th, last week. Then on April 7th, it alleges that you had your hands in your pants, moving in and back and forth, that you were told to take your hands out of your pants, and that you had been told before, or this officer had been briefed on the fact that you were known for doing this. Your response, according to this, is that that person should have asked the officers how big your penis, anyway. Since they want to be talking about you, they should have told them about that too. Then, on March 25th, before that, a week, so another officer, and these aren't the same officers, it's not the same person saying the same thing about you, somebody has some vendetta against you. So on March 25th, started to do rounds. Notice that you were watching the person doing rounds. Had his hand over his midsection as if he was rubbing on himself. March 18th, another different officer. Notice monitoring the bunk. There you are, laying on your back, stroking your penis in a back and forth motion, told not to do so. January 24th, 2025, you're in trouble for walking around. This one, notice the way you're laying on your bunk in a way, making motions under the blanket, walked past, turned around to see if you were still doing it. Then you supposedly look at this officer and say, "I'm not doing anything," while you lifted the blanket up for that officer to see it. January 4th, another time, being told to be quiet, do what you're supposed to do, didn't do it that date. December 29th, another issue of not following the rules. December 17th, another infraction for arguing and not following the rules. So if there was one time when they got the wrong person, that's one thing. That's over and over again, you disrespecting female officers who are in there just doing their job.
I'm about to show you something that makes me furious every time I see it. This is a real tax return from someone making $284,972 a year in W-2 income. And look at this, line 16, their federal tax alone is $85,231. Now you add in state tax and their total tax burden jumps to $114,108. That's 40% of their income is wiped.
I'll sleep on my back.
Sir, we're really gonna do that?
You asked me and I'm telling you, John, I sleep on my back. I have sisters, I have a mama, I don't do that. Them people write whatever they
They're
write.
making this up on you? That's terrible of them to do that.
If you look at my cases report, ma'am, I don't have any cases on none of that. I don't have any time, I'm not on no restriction on none of that.
Okay.
Up in the county.
You were off parole, the way I do the math, less than a year. So you did your whole 8 years?
Yes, ma'am.
What'd you do in prison to have to do your whole 8 years?
I was in city.
For doing what?
Just tattooing, contraband.
Not following the rules while you're in prison. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Sentence you to a term of 6 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal, and you're lucky that this was the agreement. Mr. Smith was generous. The fact is, you could have been enhanced to a second-degree felony because of your history, and you're lucky you weren't. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to Ms. Holmes. You can go with the bailiff. Good morning, sir. You're Corey Flemings? And Mr. Flemings, and is it the same in each case, or was it an agreement for a dismissal in one, or?
It was intended to run concurrent about the 8 years.
Okay, and did you do two pleas? Okay, they're both here? Okay, I'm sorry, I just saw one.
Whoa, hold up. Multiple felony cases at once? This isn't your average traffic ticket, folks. Judge West is about to walk Corey Flemings through a legal minefield. Watch closely. Every word she says now determines how high those years behind bars could stack up.
Mr. Flemings, in cause number 24, DCCR 2144, you're charged with the second-degree felony offense of assault on a peace officer from September 11th of 2024. That indictment alleges that you were previously convicted of possession of a controlled substance, a third-degree felony, September 27th of 2023. And what that means is that if you go to trial and you're found guilty, and that prior offense is true, the range of punishment would be between that of a first-degree felony, which is between 5 years and up to 99 years or life in prison. Do you understand?
Yes, ma'am. I'm sorry to interrupt.
Yes.
I believe the defendant's criminal history lends itself to being a habitual offender, and I have every intention of filing the habitual offender notice.
Okay, and Mr. LeBlanc, did you go over that with him as well?
No, you and I talked about that outside.
Oh, as far as the
25 to 99. Yeah.
So, the state has information, he says, that you have more than one.
Imagine being able to build an app.
Offender status is no joke. It's the justice system's version of a level up you don't want. It means Corey's past felonies could automatically bump his sentence to 25 years to life. Basically, if the state proves his priors, this man's future just went from bad to legendary bad.
Felony conviction from before. So if that's true, if you have at least two that are from different dates, and you are found guilty, that changes this from a first degree up to a habitual offender status, which is a minimum of 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
And in cause number 24, DCCR 2145, you're charged with the state jail felony offense of injury to a child, elderly, or disabled individual from September 11th of 2024. That indictment alleges several prior state jail felony offenses. And when I say several, I mean 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 prior state jail felony offenses. It does not allege those prior regular felony offenses, but if you have, again, two regular felonies that are sequenced, not on the same day, in that case, it would make it a second-degree felony offense for punishment purposes, which has a punishment range between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
Judge, I'm sorry to interrupt again. I want to correct the record. I misspoke. Mr. LeBlanc and I talked about it being enhanced to a regular first degree.
Okay.
5 to 99. We
Okay.
didn't specifically talk about the 25 to 99. I don't want to.
Y'all did it, but you do have the prior, so it could be. Y'all just didn't discuss it.
Yes, ma'am.
Okay, so, but you understand now, I've admonished you, and you understand, and you know what your history is. If you have a prior felony, two prior felonies that aren't state jail, and you're found guilty, then the minimum punishment is 25 years. You understand?
Yes, ma'am.
And that's on the assault case of a peace officer, and the other range of punishment in the injury to a child would be 2 to 20. You understand?
Yes, ma'am.
Okay, and so I have here on the computer plea bargain rejections that you've signed with Mr. LeBlanc that shows that the district attorney's office has made an offer of 8 years in each of those cases to run concurrently, which means at the same time. You have every right to reject that and have your cases set for trial. I just want to make sure you understand what your possible consequences are if you go to trial, what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your cases set for trial?
Yes, ma'am.
Right, we'll get it set for trial. Mr. LeBlanc will begin preparation for trial. You go back with the bailiff. All right, ma'am, you're Casey Bean?
Yes, ma'am.
And will your client waive the formal?
Wait, did he just reject 8 years concurrent? That's bold. Maybe brave, maybe foolish. When you turn down a deal like that, you're betting your freedom on a jury's mercy. Question is, does Corey know something we don't? Or is he just rolling the dice on destiny?
Reading of the indictment in each case. Ms. Bean, in cause number 23, DCCR 2068, you're charged with theft of property in an amount more than $2,500 with previous convictions, which is a third-degree felony, from April 6th of 2023. The indictment alleges you were previously convicted of theft September 4th of 2014, December 22nd of 2015, December 6th of 2017, December 7th of 2018, and June 24th of 2019. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? And then in cause number 23, DCCR 2069, you're also charged with theft of property with previous convictions in an amount more than $2,500 from June 25th of 2023. And how do you plead to that charge? That's also alleges all of those same prior offenses. And are all of those same prior offenses true? And in this case, did you enter your plea of guilty freely and voluntarily? And because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And you also understand, if you're not a U.S. citizen, that a plea of guilty or denial of naturalization under federal law.
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Bean is not competent?
No, Your Honor.
All right, ma'am. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 23, DCCR 2069, find sufficient evidence to find you guilty, and at this time find you guilty of theft with previous convictions in an amount above $2,500. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that for any time that the law gives you the right to receive. In addition to that, I will give you credit for any from the date of indictments in each of these cases, which is from November 29th of 2023. So you will receive credit from November 29th of 2023. Y'all have marked that on here as 624 days. I'm going to assume that y'all did that math correctly, but it's first.
And here comes the hammer. Notice how calm Judge West stays. That's experience speaking. Casey Bean's string of theft convictions just caught up with her. 4 years might not sound huge, but in Texas, repeat theft makes you a felony regular. One more slip, and she could face double that next time.
From the date of indictment on each case. Do you understand? And then in cause number 23, DCCR 206, which one did I just do?
6-8, was it?
Just did 9.
Well, I did the plea papers, but then which one did I make the finding on?
Do you want to know where to invest $1,000 right now? Goldman Sachs says that Elon Musk's new AI breakthrough could trigger an unprecedented market opportunity. NVIDIA CEO Jensen Huang says what Elon and his team has achieved is singular. It's never been done before. And White House AI and crypto czar David Sachs says Elon is scaling this technology faster than anyone. But if you want to claim a stake in this AI game changer, you have to act fast. Elon predicts this breakthrough will come out within the first 3 months of 2026. Blink and you'll miss the boat entirely. So, do you want to know how to get started with this technology? Stick around for the next 60 seconds and I'll show you. Hi, my name is Louis Navalier. I'm a money manager and I've been investing since 1982. I've been featured in virtually every single major financial publication and TV show. The New York Times even called me an icon among growth investors. How do I accomplish all of this? I'll tell you this, I don't come from money. My father was a stonemason and I was the first person in my family to attend college. The secret to my success is that I have a knack for finding opportunities in disruptive technologies. I bought Amazon in 2004. I bought NVIDIA in 2005. I bought Netflix in 2009, just to name a few. Investments like that helped me grow my fund from $300,000 to $1 billion and go 14 years without a losing year. But I didn't just help the rich get richer. I also show everyday people how they can build generational wealth by investing in disruptive technologies. This is a technological sea change. I'll also send you my
That I made the finding. Okay. In 23 DCCR, you good? Sorry. 2068, I'm also going to find sufficient evidence to find you guilty, and at this time find you guilty of theft with prior convictions in an amount above $2,500. Sentence you in accordance with your agreement to a term of 4 years in the Institutional Division of the Texas Department of Correction. You will also receive credit on that for any time that you've been in custody that the law gives you the right to receive, and also specifically from the date of indictment, which is November 29th of 2023. These two cases will run concurrently, which means together at the same time. I have handed you the trial court certification in each case that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. Right? Good luck to you, ma'am. You can go back with the bailiff.
And a GPS. That's your bond. Yes, ma'am. We'll just need to set it for our contested.
Are you going to plea on the motion? Have y'all talked about it?
Well, he has a new aggravated robbery.
There's a new aggravated robbery.
So that'll have to be printed up.
Okay. So we're just gonna enter pleas on the motion?
He'll enter pleas is not true and request a hearing. Yes, ma'am.
Mr. Kidd, raise your right hand the best you can, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You can put your hand down. Will he waive the formal reading of the motion?
So waived.
Mr. Kidd, in cause number 21-38744, I have a first amended motion to revoke your unadjudicated probation. It shows that you were placed on probation November 16th of 2022 for the offense of robbery, a second-degree felony, and that was a 10-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 2 alleges that you failed to immediately report your arrest to your probation officer from March 24th of 2024. Is that true or not true? Count 3 alleges that you were in an establishment licensed to serve alcoholic beverages March 24th of 2024 in violation of your probation. Is that true or not true?
It's true.
Hang on, I just need trues or not true. Count
3 should have been.
4, I'm sorry, I skipped 3. That was count 4. I'll enter a plea of truth for count 4. Count 3, count 3 alleges that you failed to provide proof of filing or attempting to file your taxes for the year 2023. Is that true or not true? Count 5 alleges that you were at a location other than your residence at approximately 1:20 a.m. March 24th of 2024. And is that true or not true? Count 6 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true? I'm sorry? Not true. Count 7 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
Not true.
Count 8 alleges that as of April 16th, 2024, you were $400 behind in payments of restitution to the victim. Is that true or not true?
True.
Count 9 alleges that you were behind in your court-assessed fees in the amount of $761 as of April 16th of 2024. Is that true or not true? Count 10 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy. Is that true or not true?
Not true.
Count 11 alleges that you committed the new offense of aggravated robbery February 19th of 2025. Is that true or not true?
Not true.
Count 12 alleges that you failed to report to the Jefferson County Probation Department since April 16th of 2024. Is that true or not true?
Not true.
Count 13 alleges that as of March 3rd of 2025, you're $1,813 behind in your fees. Is that true or not true? All right, so did you enter your pleas of true to counts 4, 5, 8, 9, and 13 freely and voluntarily? Those are the counts that you pled true to. Nobody forced you to plead true to those, did they? All right, then I'm going to find counts 4, 5, 8, 9, and 13 true, find sufficient evidence to find you guilty and revoke your probation. However, I'm going to reset your case for a sentencing hearing. Mr. Smith, if you will check into obviously that new case, we will set some time appropriate for you to bring witnesses and get any discovery that you can get to Mr. Kimler before that date.
Yes, sir.
Okay.
I'd say they're going to proceed on the administrative counts also. You play that true.
We'll make sure we have plenty of time for you.
An updated PSI.
Yes, and I'll get an updated pre-sentence report.
Those will be addressed by should be addressed by the probation.
They should, and we'll make sure we have that probation officer here as well for those administrative hearing issues. And then whatever you need as far as time for the new offense, we'll give you plenty of time for that.
And in the event that he posts bond, he needs to report to the probation department to schedule that pre-sentence report.
All right, you can go back with the bailiff.
This right here is courtroom strategy in motion. Instead of immediate punishment, Judge West hits pause, giving the defense time to regroup and gather evidence. It's a reminder that in justice, timing can be as powerful as truth. But make no mistake, once sentencing day hits, there's no reset button left to press.
And were you able to get someone hired?
Yeah.
Were you able to get a lawyer hired?
I talked to 3 lawyers, like you said. I talked to Lori Perezzo, her assistant Catherine. She said 5,000 through 7,000 was one person. I talked to Brittany Holmes, her like face to face. She said 3,000 to 5,000, and Dustin Garner is the one I'm considering going with. I talked to him through his main cell phone, and he said his prices was $8,500 to $3,500.
Okay. So how long do you think, do you have the money to try to get him hired?
Me and him discussed the case already. I talked to my uncle, which is the one who helps me pay. He said that I can, get to, I can go for him if that's what I want, because the man, everything he says sounds convincing.
Sure. So if I reset your case one more time, you think y'all will be able to get Mr. Galmore hired?
Yes, ma'am. If not, then I'll have to get a court approval.
Sure. And so, you did everything. If you think you can afford him, I'll give you about 30 days or so to see if y'all can get that worked out. If not, when you come back, remind me of what you've done, and also talk to some others and bring me those names, because there may be some others that, go ahead.
sometimes they be a little busy, cause I called several ones before that, like,
They are.
Lori Perezzo, she was busy that day, cause I think she was in court all day for criminal days.
You just have to keep trying them, but if you get him hired, bring the reset notice to him. If it's not gonna work with him, talk to a few others, bring me those names, and then when you come back, we'll talk about a court appointed if that's not gonna work out, okay? All right, step in front of the clerk, she'll give you a reset notice.
Buckle up, guys. The opening lays out the court's recurring tension. Defendants juggling the impossible cost of counsel, while the bench offers a 30-day reset. The exchange exposes family help, tentative promises, and the pressure cooker of deadlines. It frames the courtroom's central dilemma, money versus access to justice, and plants the procedural clock that will drive each subsequent hearing.
Kelby Blanchette. Good. Are you Kelby Blanchette?
Yes, ma'am.
And Mr. Blanchette, did you get someone hired?
Yes, ma'am.
Who'd you hire?
All right, Kimberly.
Is he going to be here this morning?
No, ma'am.
Did you pay him money?
Yes, ma'am. He gave me a receipt. I don't think he gonna get it, but he gave me a receipt.
Huh? He is. So do you still owe him some money? Is that, when are you going to get that paid?
Friday, next Friday.
Okay. So did he say he would, I'm thinking you probably need to get him paid off and then he'll send us the paperwork.
And I own like $200.
Right. So what I'm going to do is reset your case one more time. That'll give you time to get him all paid off, and then he can file the paperwork, and then that should take care of it, okay? Make sure you get that done and get a receipt and bring it with you next time, okay?
Kelby Blanchett claims he paid counsel, but lacks a clear paper trail. The judge probes receipts and timing. This short scene demonstrates how administrative details, proof of payment and formal filings, control whether an attorney will file on a client's behalf. Missing receipts make representation fragile. The clip spotlights the brutal bureaucracy that often decides access to counsel. Hamad.
Yes, sir. Ask the clerk. And if you'll make a notate, go ahead. At the bottom, if you'll make a notation that it's right and that he's already made a payment. Please, ma'am. Kevin Calise. Good morning. Are you Kevin Calise? And Mr. Calise, this is your initial appearance in cause number 24, DCCR 1948. You're charged with theft of property from July 1st of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Did you get someone hired already?
I've talked to somebody, but I'm willing to get somebody hired.
So what I'll do is reset your case about 30 days to give you some time to try to hire somebody. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of who you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice.
The judge turns talk into order. Kevin is told to speak with at least 3 attorneys and return with names or face a possible bond increase in jail. This segment is a demonstration of judicial leverage. The bench mandates documented steps, converting vague plans into enforceable requirements. It's a procedural pivot that forces accountability and raises the stakes for follow-through. Hamad.
Diamond James. Good morning, ma'am. You're Diamond James. And did you get someone hired? Speak up, please.
No, ma'am.
Who'd you talk to?
I spoke with Kyle Walker. He said $7,500, but no payment plans on a down payment.
Okay.
I spoke with James R. Macon. They said $7,500 as well. I spoke with Franklin and Associates. $10,000. The minimum is $7,500. $500 every 2 weeks was the way we work. has been going, the hours have not been 8 hours a day, so.
Right. So thank you for doing what I asked you. I'm going to let you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely because you're going to swear under oath that it's all true and correct. So put whatever your bills are, whatever your income is, and then I'll take a look at it. If you step in front of the clerk, she'll give you that those instructions. Kingston Walker. When did you ask for a tech? How long? I was about to say that's been 35 minutes. Good morning, you're Kingston Walker? And Mr. Walker, you were previously here and given some time to hire a lawyer. Did you get someone hired?
I spoke to multiple lawyers and I chose a lawyer, but I just need time to forward the payment.
Who'd you talk to?
Burbanks.
Okay, and you're planning on hiring Mr. Burbank?
Yes, ma'am.
All right, so, and you're working?
Yes, ma'am.
Okay, so what I'll do is reset your case about 30 days to give you some time to see if you can get him hired. If you do, just bring that reset notice that you get today to him in his office and they'll tell you what to do. If for some reason it's not going to work out with Mr. Burbank, then I'm ordering you to visit with at least 3 others. See if one of those works out. If fine, great. If not, bring me those names so I know you're trying, okay?
Diamond and Kingston illustrate the affordability problem. Steep retainer quotes push one toward court-appointed paperwork, while the other names a lawyer he can't yet afford. The judge methodically triages cases, offering forms, setting reset dates, and nudging defendants toward public defense when private counsel is impossible. The clip reveals how the court balances scarce resources and procedural fairness. Hamad.
All right, step in front of the clerk. She'll give you that reset notice. Tyron Williams. Good morning. You're Tyron Williams? And Mr. Williams, did you get someone hired?
Benjamin Jeffries, but I'm still trying to get some money together.
Okay, so you're planning on hiring Mr. Jeffries. Have you made any payments yet or not?
He won't half of it before he started doing it.
Okay, so what I'll do is reset your case about 30 days. Your case is getting old. It's indicted some time ago, and the offense date was obviously early last year, so you need to try to get him hired if you can before that next court date.
Okay.
If it's not going to work for some reason with Mr. Jeffries, make sure you talk to at least 3 other attorneys, and if you can't hire any of those, bring me those names so I know you're trying, and we'll discuss your options. Okay, step in front of the clerk, and if you'll put Jeffries on there as well, please. Thanks. Diamond Ollie. Yeah, Summer told me. If you'll call the name Diamond Ollie.
Diamond Ollie.
I'm just wondering if I need to send an actual text message or something. Did you?
Text it. I called and told him, and then I sent him a message, and then I texted him since. She said, there was one shot on the text.
All right, her bond will be forfeited for non-appearance and reset at $100,000. She did call and say she was having car trouble, so if she gets here, just let me know, and I'll recall that. Christian Ainsworth. Good morning, are you Christian Ainsworth?
Yes,
and Mr. Ainsworth, did you get someone hired?
I did.
Speak up.
No, ma'am, but I did talk to 3 attorneys.
Who'd you talk to?
The law office of James, Macon, Attorney Williams, Marcus Wilkerson, and law office of Brittany.
Okay, and where are you on being able to get someone hired?
It's not looking likely.
This stretch compresses multiple defendants into brisk judicial directives, promises to hire, missed appearances, and a bond forfeiture for noncompliance. The judge's no excuses posture and repeated resets underline that this courtroom runs on deadlines and documentation rather than assurances. The exchange shows how ordinary procedural mechanisms produce meaningful consequences for those who fail to comply. Note, Hamad.
Are you working?
Yes, ma'am, I am.
Okay, where do you work?
Raising Cane's.
Okay, full-time?
Part-time.
All right, what do you do the other part-time?
I was in school, just right now I'm in school.
You're not in school? Sounds like you need to go get another part-time if you're not in school.
This one.
right? I mean, it'd be great if you were in school.
It would. I was thinking about going back this semester, but my mind hasn't been in the right spot.
Okay. Obviously, you know that that'll help you and get your mind in the right spot if you're all that extra time you have is doing nothing to get your mind in a better place, right? So I'm going to reset your case one more time. See if you can save. Listen.
I feel like, can I say something?
What?
I just put my life on hold with this case. Like, it's been getting reset. And I just.
You want to know why it's getting reset?
Because you give me time to find a lawyer.
Right. Go get another job. If you're working part-time, you have time to get another job. And if you're working 2 jobs and you still can't afford one, I'll give you a court-appointed attorney. But I'm not just going to hand it to you because you're hanging out for 3/4 of the day and working part-time at Raising Cane's.
I work every day. I just don't work. That's fine. No excuses.
No excuses. Bring me do 2 things for me. Number 1, try to get more hours there. Bring me a pay stub to show me what you're doing when you come back. Talk to some other attorneys just to see what they charge so you have some options. And see if there's something else out there and tell me where you've applied for some other jobs. All right? Show me that you're trying harder and then I'll help you. Does that make sense? Step in front of the clerk. She'll give you a reset notice. Krishara Bennett. Good morning, ma'am. You're Krishara Bennett? Miss Bennett, did you get someone hired? Who'd you talk to?
Christian's raw "My Life on Hold" meets the judge's blunt reality check. Get another job, show pay stubs, and prove you're trying to hire counsel or qualify for a court-appointed attorney. The bench gives concrete, measurable tasks designed to produce verifiable progress, not sympathy. This clip captures the tension between human vulnerability and institutional demand for evidence of effort.
Okay. And tell me where you are on being able to get somebody hired.
I'm not able to meet the requirements of the payments that they're asking for.
Right.
I do work, but I don't get paid.
Where do you work?
The trust for the VA.
Okay. So what I'll do, Ms. Bennett, is have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely, whatever your income is, whatever your bills are, and then I'll take a look at it. You're going to swear under oath that it's all true and correct, all right? So if you'll step in front of the clerk, she'll give you that paperwork. Marquise Berry. Good morning, you're Marquise Berry, and this is your initial appearance in cause number 25, DCCR 0882. You're charged with aggravated assault with a deadly weapon from April 20th of 2025. Since you made bond in your case, have you had an opportunity to try to hire a lawyer? Are you working?
No, I'm gonna do this. I'm 7 years pregnant.
Did you bring any documents that show you're on bed rest?
Oh, I don't know. I need to do this.
Okay, so what I'm going to do, Ms. Berry, is I'm going to reset your case for about 2 weeks. You need to bring me some documentation from your doctor that says that you're unable to work right now, okay? And then we'll discuss what your options are. Make sure you bring me back that documentation. Are we here next week? Next week's a normal week.
Yes.
I'm going to reset it 1 week. Get that documentation and bring it back next week. Step in front of the clerk, she'll give you your reset notice. And if you'll make that notation as well. Thanks. David Calderon.
Bennett is funneled toward a court-appointed application, while Maris Berry claims bed rest and is given a compressed 2-week reset to provide medical proof. The moment alternates between administrative procedure and an urgent health claim. The court balances compassion with the need to keep the docket moving. It's a compact example of how personal emergencies intersect with legal timelines. Hamad.
Good morning, sir. You're David Calderon? And Mr. Calderon, this is your initial appearance in cause number 24, DCCR 1428. You're charged with the state jail felony offense of unauthorized use of a vehicle from May 20th of 2024. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am, I haven't had an opportunity. I've actually been working on getting my civics taken care of. And I brought some documentation here to show that.
To get your what taken
My
care of?
civics taken care of as far as like transportation, a job, shelter.
Okay.
Basics. I'm just coming. It's probably been like a month or so since probably like a month and a half.
Since you got out of jail?
Yes.
Okay, so what I do, Mr. Calderon, is I'm going to reset your case about 30 days to give you some time to do a couple things. One, if you don't have a job, try to get a job, obviously, but also try to at least talk to some attorneys to see what their prices are. They all charge different amounts. They have different payment plans. I want you to talk to at least 3 lawyers. I also want you to bring me proof of jobs that you have applied to and things like that. Let's see where you are in 30 days. If you follow all those instructions, bring me the information about where you've applied for jobs, if you've gotten a job, who you've talked to, then we'll discuss whether or not I'll let you fill out the paperwork for a court-appointed lawyer, okay?
I was gonna say, ma'am, I have a paper here, so I just got hired last week at a job, but I also brought some documentation to show my financial status right now and what it is that I'm responsible for.
Bring all that back next time, but I'm, at least when you bond out, I want you to at least try to hire a lawyer, okay? If you haven't talked to them, you don't know how much they charge and what your options are, so I want to make sure you do all of that, then we'll discuss your options. Bring all of that also back next time as well, okay?
Can I get a little bit more than a month?
Now, everybody gets 30 days. Just show me what you've done in 30 days, and then if you need more time after that, if you've done what I asked, then we'll do that.
Yes, ma'am.
But I just do 30 days to make sure everybody keeps doing what they need to, okay?
Yes, ma'am.
Step in front of the clerk, she'll give you that reset notice. Derek Mouton?
David Calderon returns recently released with some documentation and a new job, but the judge demands demonstrable proof of progress. Job applications, attorney contacts, and financial documentation. The bench frames mercy as conditional on verifiable steps toward stability and counsel. This clip shows how reintegration is measured in paperwork and outreach, not just promises. Hamad.
Good morning, you're Derek Mouton?
Yes, ma'am.
Mr. Mouton, were you able to get someone hired?
I spoke to somebody about, I'm gonna say, the next 2 weeks, I have somebody out.
Who's that?
Miss Brittany.
You're planning on hiring Miss Holmes, and you can do that within a couple of weeks?
Yes, ma'am, I should be able to do it.
So I'm going to reset your case one more time, a normal reset. That gives you 30 days to get her hired. If you get her hired before then, just bring this reset notice to her so she knows that court date and she'll let you know what to do.
Yes, ma'am.
If it's not going to work out with her, then you need to talk to at least 3 other attorneys and bring me those names when you come back. Okay? Step in front of the clerk. Thank you.
Thank you.
Darius Sparks. Good morning, you're Darius Sparks. Mr. Sparks, did you get someone hired?
I'm talking with Dunham and Jones.
Who?
Dunham and Jones is a law firm.
Uh-huh.
They got a deposit of $750, so I'm setting up.
Okay, and you're working still?
Yeah, I'll get to this.
Okay. And do you know the name of the attorney there that you're talking to?
No, ma'am, it's a widespread piece of that.
Okay. So if you just put Dunham and Jones down, that's who he's, I'm going to reset your case about 30 days to give you some time to get them hired. If you do, make sure you bring that reset notice to them and they'll tell you what to do. If that's not going to work out with them for some reason, you can't get them hired, you need to talk to at least 3 others and bring me those names. Okay? Step in front of the clerk, she'll give you a reset notice.
I know it, I'm killing you. I'm killing myself. Be like a block.
Derek pledges to hire Miss Holmes, and Darius reports a $750 deposit. The exchanges reveal routine legal logistics, small payments, fuzzy firm names, and continuing uncertainty. The judge's procedure-driven approach keeps cases moving through resets and follow-ups. This short passage typifies how modest financial moves and vague promises keep individuals in legal limbo while the docket churns. Hamad.
All right, sir, you're James Lofton?
Yes, ma'am.
And Mr. Lofton was previously in court. Now, the misdemeanor is something that, remind me, why do I have that on?
He was supposed to have pled to his misdemeanor several resets
Right.
ago each time prior to coming down here, because our plan is to have him, we had talked about
To extend
ISF,
probation and ISF.
but now it's for safety if the court considers based on this update PSI, but obviously we can't do that until he pleads to the misdemeanor.
Well, I can do that today, and he can go into custody, and y'all can go take care of it.
That's what I was just gonna.
Because he'll sit in custody until he goes and
Correct,
takes
that's-
care of that other case, because he won't go. All right. So in cause number 16-24485, first year James Lofton. Mr. Lofton was previously in court, and that is a motion to revoke probation. On probation for the third-degree felony of assault, family violence. It was a 5-year deferred at one point, and then in February of 2020, that probation was revoked and given a 10-year term that was probated for 5 years, so went to a straight probation, placed on high-medium caseload and zero tolerance. I've received the updated pre-sentence report also. Has everyone had an opportunity to review that report?
Yes, ma'am.
I have your.
Any additions or corrections to that?
No, ma'am, the only thing I would say is since PSI is that we have this last.
The hearing pivots into James Lofton's troubled history, deferred sentences, revoked probation, and PSI planning. Defense and the bench begin parsing a pre-sentence investigation, signaling that this is no longer just a scheduling matter. This clip plants the seed of escalating consequences and reframes the session with real sentencing risk. Hamad.
Snap your W-2.
Welcome back to Law Next.
I guess that's it. Where'd my picture go? There it is. All right, well, I'm going to call this a day. Again, I thank everybody who watches my content. Thank you. Your support means a lot to me. And like I said, welcome to all the new subscribers. Welcome to the channel. And if you like this content and you're not a subscriber to this channel, please do me a favor and subscribe to this channel, and let's help this channel grow. And if you want to put this out on the social media, please be my guest. You have my permission to put it out on social media, X or Facebook. So that's it for today, ladies and gentlemen. Tomorrow is Judge Rhonda Bailey. Tomorrow is Judge Rhonda Bailey. So you all have a wonderful evening. Ta-ta and ciao, and I will see you on the next one.
Breakdown, you're the one I call. From the mountains high, come down to it all. With your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, you fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. Daniel, you make it better. From the wires tangled up to the broken dreams, you know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, you fix it all. Daniel, you make it right. Daniel, You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time.